The meeting of the Nuisance Abatement Board is hereby called to order. I'm Gary Baker. I'd like for each of our members to introduce themselves, starting to my right.
Meg Taylor.
Frank Persichino.
Daniela Sherrod.
And we'd like to welcome Member Sherrod.
Thank you.
This is your first meeting. We're glad to have you. For our first order of business, we will consider the minutes of the June 7, 2023 Nuisance Abatement Board meeting. Do I have a motion? Everyone has been submitted with copies of those minutes.
Motion to approve.
Second.
So we've received a motion to approve the minutes of the June 7, 2023 Nuisance Abatement Board meeting as submitted in written submission by the city clerk. It's been seconded. All in favor?
Aye.
Aye. Unanimously passed. Now is the time to hear from citizens who wish to be heard regarding items not on the agenda. Do we have any such citizens that wish to be heard? Okay. We'll then go on to our next item, which is the old business items. We're going to discuss the status of case number 2022-01, City of Clearwater versus the State of Josephine Dixon. So,
I'm prepared to update on that. Yes, Melissa Isbell, City Attorney, Assistant City Attorney. So as you all recall, other than Mr. Sherrod, last time we were here, you heard in the entirety the case that the city brought against the estate of Josephine Dixon. What your findings were in that case were that the property was a nuisance, and then you assessed the investigative costs and the attorney's fees at that time, and then we held in abeyance the fine. If the estate members complied with the requirements that you all set up, we would then agree to get rid of the fine. That would have required that they got cameras in place, put motion detector lights in place, and contacted the Clearwater Police Department, confirming all of that and giving them access to those cameras. To date, Lieutenant Wanos, who was the case manager that you heard from on that particular case last time, has not heard from the Dixons and has not received any information that those terms were complied with. So we are asking that you do impose the totality of that fine, which according to your last order is $2,250.
As a matter of due process, was the estate notified of the hearing today?
I would ask Madam for.
I didn't provide the notice because you guys handled the notice the last time.
Okay, my understanding is that their attorneys were noticed, Mr. LaRoe was noticed, so that is what I'm aware of.
So do we have a copy of the notice of hearing that was provided to Mr. LaRoe? So the board has that?
I don't at this time. I would have to ask Ms. Berbes.
Okay, so the question here then is what has due process been provided to the estate? You can see that there's nobody here from the estate, and I want to just make sure before you take any action against the estate that they're aware of the hearing going on today. So as a representation of an officer of the court, the city attorney is saying that they've been notified of the hearing today, and so you can rely upon that, or you can continue the hearing until a future meeting and receive the actual written notice if you wanted to do that.
I believe we also have a copy of the notice that the order was served upon the defendants. And the order set forth what needed to be done.
Correct.
And it's my understanding that we're receiving testimony today that none of that has been done.
So there's not any testimony. There is a presentation by the city attorney that has not been done. But the concern I have is that if the property owner has no notice of the meeting today and has in fact done everything that they're supposed to except calling the police department and telling the police department that they've done it all, that's a different thing than having not done anything at all. And so I just want to make sure that before you move ahead and assess the fine, that you feel comfortable with the fact that with the representation of the city attorney, I do, that notice has been given, then you can move forward with that. So, or you can continue to the next hearing and get the actual notice that was sent to the attorney. We just don't want it to be overturned on a due process argument.
When would that, what date would that push it to?
The committee typically meets on the first Wednesday of the month, so if we can schedule it on the next, so that would be,
Early November?
it'd be early November, but just to be clear, it'll be November 1st actually, would be the first Wednesday of the month. So that would be the soonest I would schedule it.
If I may, we may have one witness who would be able to testify that she observed the notice posted on the property herself, and if that is what the members are open to, or we can go ahead and reschedule that. It's up to them.
Let's go ahead.
Hi, I'm Chelsea Gerd.
Hold on a second, I need to go ahead and swear you in under oath. If you could just raise your right hand, you swear that the testimony you're about to give is going to be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
State your name again.
Chelsea Gerd. I'm the president of the Foster Park Neighborhood Association. I live in the neighborhood, so I'm very aware of this house and the situation going on with it. I drive by it every day. The notice was posted on the front door, and I've also talked to a city guy who came and was asking because he didn't know where anybody lived, but he knew the property address, so he posted it on the door. And then a couple of days later, they came and mowed the lawn, and the notice was gone. So I just want to let you know that information.
So just before you sit down, are you saying that the notice of the original hearing that took place in June was the notice on the door, or the notice for today's hearing?
Notice for today's hearing.
Gotcha, okay.
Would you have any information on whether anything was done? I
Nothing's
mean,
been
other
done.
than the lawn mowing?
No, nothing's been done.
And you know this?
Yeah.
Have you observed any new cameras at the property?
There is a door camera, like, you know, like, it's not a ring, but it's like right on the front door. So, I mean,
And any change in motion sensor lights?
no, there's no motion or sensor lights. I mean, I walk around the park and we own property on that street, two of them, my mom does, and so we go there all the time.
And just to remind the board that along with installing multiple cameras, it was also to provide access to the police department where there are requirements to fulfill it in its entirety. Thank you, Ms. Gerd.
Do we have a motion?
Any discussion?
Any discussion?
I just, I prefer to see a confirmation that they received their letter, via signature or whatever, or whatnot, whatever you would
When
get.
it was officially sent?
Yeah, I mean, they were over at a code enforcement meeting just last week, so, they showed up last time that we had a meeting here, so they don't seem like.
They were at a code enforcement meeting last week.
Yes. So, it doesn't seem like they don't want to show up for these kind of things. I feel like I prefer to have a confirmation of notices than, even a posting. I'm not sure if that's legally adequate.
So the answer is, it can be posted and it can be sent by certified mail. Normally the city would do all of that, regular mail, certified mail, and the posting of the property to make sure that there's notice.
Okay.
And then the regular mail, obviously, if it doesn't come back, you can assume that it was received. The certified mailing, sometimes they get the green card back, and that can be proof. You can see that in the packet that you had for the first complaint, you can see how that was done in the first part of the case. So it was probably done for this too.
Okay.
And then that could be provided as well. So those three opportunities, in addition to the police department may have served it by hand.
Okay.
That's another option too. So far, we've heard it's been posted.
And that would be adequate?
It would be adequate, yes, posting.
Then that's fine with me then.
Just for the record, I didn't see what the note said, I just saw that it has the city of Clearwater seal on it.
Okay, that's not the same thing.
Yeah.
Yeah, considering there's also a code enforcement case, it could be a code enforcement letter too.
That's true. It could have been something other than this particular case. So maybe the more appropriate thing to do would be to motion to postpone it to the November 1st meeting to ask the city attorney's office to provide the notification that was to the property owner. And if it was received, then you could move forward.
Right.
I would feel comfortable with that.
So November 1st.
We just
Yeah.
need a motion to do
Motion
that.
to move the meeting to November 1st.
Second.
And who would be providing the notice that we're waiting for?
City staff, or the city attorney's office would be doing that.
City attorney's office?
Yeah.
We'll have it for you next time.
Okay. Any other discussion? By the way, nothing that was in the order would be adversely affected by this change of date.
That is correct. Everything, the investigative cost is already static. The attorney's fees is already static. In other words, it's not changing. Those are, if they haven't been paid already, they're accruing interest at the statutory rate. The only thing that the city attorney is talking about today is the $250 per item of this 9 separate dates. So in other words, $2,250 was the actual fine assessed. And that your ruling provides that the fine shall be suspended until the Nuisance Abatement Board meets and determines that the respondent has failed to comply with paragraphs 2 and 3 above. Should the respondent comply with paragraphs 2 and 3 above in a form acceptable to the Clearwater Police Department and approved by the Nuisance Abatement Board, the fine shall be waived. And so you've heard argument from the city attorney, and you've heard from the witness too, that some of the things have not been completed. Let me just read paragraphs 2 and 3 because we have one board member that wasn't present at that meeting. Paragraph 2 says, the respondent shall install monitoring cameras and provide access of the camera/video feed to the Clearwater Police Department on a real-time basis within 60 days of the date of this order. Paragraph 3 said, respondent shall install exterior lighting with motion detection sensors within 60 days of the date of this order. And also to remind you that the order was signed June 9th, 2023. So obviously 60 days have already elapsed. Okay.
So that wouldn't extend their time they had to complete it?
No, they had to do it within 60 days.
Any other discussion?
Madam Clerk, what time did you have the meeting on the 1st?
It'll be at 3 o'clock, they're normally scheduled.
And what date is it?
November 1st, Wednesday, November 1st.
So our motion is to continue this hearing to November 1st at 3 p.m. All in favor?
Aye.
All opposed? Motion carries. I don't think we have anything else on the agenda unless staff brings something to it. So do we have a motion to adjourn?
Motion to adjourn?
All in favor?
Aye.
Aye.
Thank you.
Thank you, everyone.